I'm going to talk about the defence statement. The legislation for defence statements is set out at the Criminal Procedure Investigation Act 1996, Section 5 and 6. It is also set out at the Criminal Procedure and Investigation Act Defence Disclosure Time Limit Regulations 2011, and it's also set out at the Criminal Procedure Rules Rule 22.4. So what is a defence statement? Well, for a defendant who pleads not guilty and is going to trial, a defence statement is a document that they serve upon the prosecution and upon the court ahead of trial, and that defence document sets out in broad terms the nature of the defence that the defendant will adopt at trial. It can be a useful document for helping the defendant prepare their matter for trial. So it can assist the defence in preparing the matter to go for trial. A defence statement should set out in broad terms the nature of the defendant's defence. So for example, if this is a case of alibi, a defence statement may want to set out where the defendant was at the time of the alleged offence, who the defendant was with at the time of the alleged offence, and how the police can contact the individuals that the defendant was with at the time in order for them to give evidence of alibi. Likewise, if this is a case of self-defence, if it's an assault allegation, if the defendant accepts that they did have an altercation with the individual, with the alleged victim, but they acted in self-defence, then a defence statement can set down in some detail the nature of the accused defence, the self-defence, can set down the details surrounding the reasons why they acted in the way they did. Or if this is a matter that involves consent, if the defendant had consent or if the defendant believes they had consent, a defence statement can set out in some detail the nature of the defendant's understanding and that they believed that they had consent at the time. So a defence statement can be quite a useful document for the defence to make use of. There are time limits for defence statements to be served, and the time limit starts once the prosecutor has served their initial disclosure. Once the initial disclosure has been received, and provided that has been correctly disclosed, then in the magistrate's court the time limit is 14 days from the initial disclosure. A defendant does not have to provide a defence statement at the magistrate's court. It's not compulsory, but if they choose to, then it's 14 days. At the Crown Court or at the court-martial, it is compulsory to serve a defence statement, and that must be served within 28 days of the initial disclosure of the prosecution case. If a defence statement is not served at Crown Court or at court-martial, then it may be that in some circumstances the court may draw an adverse inference at trial as to why the defence statement was not served, or if the defence statement was served late. It is possible to ask the court in writing for additional time in which to serve a defence statement. Once the defence statement is served, the prosecution is then under an obligation to go back to the case, to look at its case afresh in light with what has been disclosed within the defence statement, and to undertake a further review of the prosecution evidence, a further review of the unused material, to see whether there is any material that the prosecution has gathered during the case that may assist the defendant's defence as a result of what has been disclosed within the defence statement. So as I said, a defence statement can be a useful document in the defendant's armoury in preparing their case for going to trial. So the Criminal Procedure Investigations Act 1996, Section 5 and 6 sets out the contents or the required contents of a defence statement. So a defence statement should include the nature of the defence. including any particular defences on which the defendant intends to rely. A defence statement should indicate the matters of fact on which the defendant takes issue with the prosecution. A defence statement should set out, in the case of each such matter, why the defendant takes issue with the prosecution. A defence statement should set out particulars of the matters of fact on which the accused intends to rely for the purposes of their defence. And a defence statement should indicate any point of law which the accused wishes to take and any authority on which the accused intends to rely for that purpose. So, in summary, the Criminal Procedure Investigations Act 1996, Section 5 and 6, set out the requirements for a defence statement. A defence statement is voluntary at the Magistrates' Court and compulsory at the Crown Court and Court Martial. At the Magistrates' Court, once the prosecution has complied with its duty of initial disclosure, there are 14 days in which to serve a defence statement. At the Crown Court and Court Martial, once the prosecution has complied with its initial duty of disclosure, there are 28 days in which to serve a defence statement. A defence statement should set out in broad terms the nature of the accused's defence at trial, and a defence statement should be served on the prosecution, on the Crown, within either 14 days at the Magistrates' Court or 28 days at the Crown Court or Court Martial.